So look, most of foreclosure world, and frankly, a lot of the legal world has been waiting for a very important question to be answered by the court, and that is whether or not the statute of limitations applies in the context of foreclosure cases. If you've watched any of these videos, you'll note that I've posted the oral arguments on the two cases that are of issue, Bartram out of the 5th and Beauvais, which is out of the 3rd down in Miami. The whole issue of statute of limitations has been of great importance to lawyers and consumers because there's literally billions of dollars worth of mortgages across the state of Florida that hang in the balance. Many consumers and some attorneys believing that there was a statute of limitations that would be applied in the context of foreclosure cases. Now, from the very beginning, I've said that there is no way that the Florida Supreme Court, and frankly, I can't see that in the appellate courts, are in the end going to find that the rules that apply to you and I and every other party regarding statute of limitations would be made to apply against the banking industry. The reason for this is a very pragmatic analysis. Again, I just can't find that even if that is the law today regarding statute of limitations and for all other debts, I can't find it in my legal analysis to believe that the appellate court, or frankly any court for that matter, is going to find that the banking industry in this state is not entitled to collect debts and not entitled to act under a completely different set of rules than the rest of the actors and litigants that appear before courts. Just today now, we find the first indication that my analysis is correct. We have an opinion that's released out of the 3rd DCA, a rehearing of the Beauvais opinion, which started this whole discussion last year. So today, April 13th, 2016, the 3rd DCA released their opinion on the rehearing of Beauvais, and in that opinion, they again adopt the analysis that I was pretty confident they were going to, which is to say a different set of rules applies to the banks. Beauvais in the 3rd DCA picks up this analysis that comes out of a Florida Supreme Court case, Singletary, and it is unfortunately quite unfortunate, but what we see is a continuation of a pattern where the court system defines a completely different set of rules for the banking industry than they would for other parties. And unfortunately, that's an avenue that we will see courts going down much more frequently. And in fact, I think you'll see that with a very consistent pattern going forward. We're certainly seeing that coming out of many of the appellate courts across the state, where increasingly the rights of consumers, consumer law gets defined in very narrow ways, very unfavorable towards consumers, and in my estimation, the larger interests of justice. But if you're a consumer, if you're a litigant, if you're a lawyer that's been waiting for this statute of limitations opinion, here it is. You'll see it posted here within this post. I encourage you to read it in depth. It's a 66-page long opinion, and that should give you some very clear analysis or insight into where the Supreme Court is ultimately going to wind up.